I'm working on the railroad. That's how I work. Before me, the underdesigned notary public on this day personally appeared Mike Howard, who being by me duly sworn, deposed and stated as followed. I, Mike Howard, am at least 18 years of age, of sound mind, and I am competent and qualified to make this affidavit and have personal knowledge of the facts that stated herein, that they are true and correct. I declare that I was the trial counsel, supported by second chair co-counsel Toby Shook, third chair co-counsel Tasha Gupta, and briefing appellate co-counsel Michael Mauler, who represented Karmelo Anthony in the cause number of, going to the cause number, leading up to the June 1st, 2026 trial of this case. And the defense and prosecution reached an agreement where the prosecution and defense jointly agreed to not raise any alleged character, reputation, or extraneous offenses, bad acts, evidences relating to Mr. Anthony, as well as Austin Metcalf and Hunter Metcalf during the trial, hereinafter referred to as the agreement. Bruh, you my homie, but you agreeing with the ops. Yo, bruh, if I was King Vaughn and you was doing that, Courtroom, when Jesus comes. Are you on 64th Street talking to the ops talking about you making agreements, homie? You're not doing that because you know Vaughn didn't care. He had beef forever. How you doing that, bruh? That's nasty work. Agreements. I've been telling you in this video that they've been making agreements, but now we see specifically. Nah, I'm glad I went to put page to exhibit 10. Nah, bro. I'm gonna read over these exhibits later on today and get y'all through the fluff. And we reading them saying the same shit about a bunch of shit. To hell with that. Let's get to the fucking the potatoes. And I ain't gonna say the other thing because that's pause. But the potatoes. Look, the lead prosecutor in this case, Bill Werski, brought up the possibilities of the agreement a number of times well before the agreement was discussed in detail and eventually reached. When mentioning a proposed agreement, Mr. Werski proposed that we try the case clean. This was the weird thing that I read before, which he defined as based only on what happened under the tent that day. So what if those twins didn't like Karmelo from the beginning, had some bias towards him from the beginning, because we seen Eddie and him in the defense's photos. He was sitting next to him at a track meet, and Eddie played for their team. So what's the chances that they could have seen Karmelo too and known who he was too? He was playing on the football team, seemed like he was pretty good. He was playing, he was running on the track team, seemed like he was really fast and he was good at that. So what's to say that they didn't know him? They can even go into it. Your defense is making agreements already, bro. No, we don't want no agreements. Bring up his past and bring up your past. Let's go. Let's go. Because I guarantee you that them boys' past is more speckled than his past. Okay, cool. Nasty. Under the tent that day, under the Memorial High School tent in the stadium on April 2nd, 2025. And not to go into character, reputation, or extraneous offense and or bad act evidence applicable to either Austin and Hunter Metcalf or Karmelo Anthony. On May 5th, 2026, Mr. Shook and Mr. Werski discussed this proposed agreement. I'm about to do my Stevie Wonder routine in one moment. Just wait. Agreement by phone. During that phone call, Mr. Shook and Mr. Werski discussed the evidence of character, reputation, and extraneous offense and bad conduct as it applied to both the Metcalf twins and Karmelo Anthony. Mr. Werski reiterated that he would be happy to try this without getting into character at all. Just on what happened today in the track meet. What is we doing? Yo, bruh. Nah. Who with me, bro? Who with me on this railroad, bro? Who's with me? Bruh, your defense making agreements with these people for what, bro? These people ain't your friends, homie. You from 63rd, they from 64th. You heard Vaughn. What's wrong with you, bro? We ain't friends, bro. We used to be friends when we was kids, but we ain't friends no more, bro. What happened to that? Nasty work. On May 8, 2026, the defense and the prosecution teams met in the Collin County grand jury room, and the prosecution team gave us a document entitled State's Notice of Intent to Use Extraneous Offenses. Hereinafter, the state's notice, and we gave to them a document entitled Anthony's Motion in Limine. That's this word, limine. Okay. That's when they don't want you to say certain things in front of the jury. So they'll strike things, or they'll make a motion to say, oh, listen, man, I don't want the defense or whoever to say something that can contaminate the jury. So that's called limine, right? Boom. Regarding the admissibility of pertinent character trait evidence under the ambiguous aggressor rule. We got to go into that, bro. We got to go into that now. We got to break into that. What's that? What's the ambiguous aggressor rule? What's that? Scared of that. Scared of that. We getting on our Matlock shit now. Scared of that. I'm not playing none of these niggas. In plain English, y'all. Listen to me, y'all. You know, we're going to break this thing down for you. I'm going to get you on your shots. Look, if evidence doesn't clearly show who the initial aggressor was, the jury may be instructed to consider that uncertainty when deciding whether the defendant acted lawfully in self-defense. Let's read that again, bro. If the evidence doesn't clearly show who the initial aggressor was, the jury may be instructed to consider that uncertainty when deciding whether the defendant acted in a lawful self-defense. It's not a standalone rule that automatically favors either side. Instead, it recognizes that when the identity of the first aggressor is genuinely in dispute, that the jury must evaluate all the evidence before deciding whether the self-defense applies. So a simple way for us to break it down is the ambiguous aggressor rule comes into play when the evidence doesn't clearly show who started the confrontation. So if the jury can't determine who was the first aggressor, which we know who the hell it was, the hell y'all blind? Don't let me go back into my Stevie routine. They had to carefully consider all the evidence in deciding whether the defendant was legally justified in using force. My Sherry Amore. My glasses out, man. My Sherry Amore. Stevie could see that railroad more and more. Jesus Christ. The evidence under text code, they break down the code. Hereinafter, the defense notice. After the tendering to each other our respective extraneous filings, briefings, we then discuss the proposed agreement, which Mr. Worski referred to as a gentleman's agreement. Gentleman's agreement? What do you think we doing here? Sipping tea? How many lumps you want, sir? Mr. Worski outlined the proposed agreement as followed. Both sides tried this case without character, reputation, or extraneous evidence for either the Metcalf twins or Karmelo Anthony. Who is this guy, Mr. Worski? Who's Mr. Maybe, yo, hold up, man. Hold up, y'all. I have to do this. Who's him? Who is Mr. How you spell his name? Because he sounds like a straight op. Word ski. Man was a Viking in his past. Worski. Hold up. And Karmelo. Hold up, son. We gotta do this, bruh. We gotta do this so we break this down the right way. Who is he? Look at who's coming up with this deal. I already thought I knew who he was, but I just wanted to be factually correct. That's why I like to do facts. I don't do the guessing games around here. Okay, lady, you gonna be with me or you ain't gonna be with me? You better get on your high heels and go. I ain't with it. I'm with the facts, lady. I ain't guessing games over here with me. See what I'm saying? So look, Bill Worski is the first assistant district attorney for Collin County, Texas. You don't say. Oh boy. And he serves as the lead prosecutor. Oh boy. in the Karmelo Anthony M trial, and he presented the state's case to the jury, handled witness examinations, and delivered the prosecution's argument, and later defended the verdict publicly after the trial. I ain't gonna do the Stevie routine yet. We're gonna save Stevie. My glasses is here. Anytime